Hi, everyone. I'm Bill Squadron, President of Our Energy Policy, and welcome to our webinar today on the rise of climate litigation. We've been wanting to do something on this topic for quite some time, the importance of moving policy forward through litigation and the pros and cons of doing so. We have an extraordinary panel that's poised to discuss this issue over the next hour. A couple of quick reminders for all of you in the audience. We will get to questions toward the latter part of the hour. There's a questions tab on your dashboard. Type in your questions, send them in, and we'll get to as many as we possibly can before we wrap up. I also want to thank all of our supporters, sponsors, partners. We have, as I think you all know and can see, a very wide range of partners that support our mission of bringing together diverse viewpoints, perspectives from leaders and experts on energy issues that is done in a civil and substantive way, and then using that really as a way to advance sound policymaking in the energy space. So thanks to all of our partners for supporting OEP's work. And I also want to direct all of you to OEP's website and our resources area, which is available to everyone working in this field and is really the best documented, most comprehensive library of articles, reports, studies, papers, and so forth on all manners of energy issues, and that's in the OEP resource library. Without further ado, I'm going to turn it over to Michael Dorsey. We're particularly grateful today to Eberson for co-hosting this event. Michael is going to give some opening remarks and then introduce the panel. Michael is the co-founding partner of Eberson Solar, which is a Spanish-U.S. Utility scale developer. He is a globally recognized expert on energy and environmental matters across business, nonprofit, academic, and government spheres. So we're particularly excited and grateful to have Michael with us today. Michael?
Bill, thank you so much. At Eberson, we're really pleased to be a partner with Our Energy Policy. At Eberson, we deliver renewable energy every step of the way at the utility scale for our commercial and industrial clients. And we really value addressing and solving tough problems in the renewable space, certainly, but also moving critical conversations that we face globally and across our various markets. So it's truly our pleasure to be a partner with OEP to help drive this really important conversation and more like it going forward in the future. So it's also my pleasure today to introduce our moderator, a colleague, a friend of mine, I'm happy to say, Mr. Graham Arian, a Canadian. He's also the Vice President of Mergers and Acquisitions and Structured Finance at the Toronto-based Carbon Free Technology. Graham, take it away, please.
Thank you, Michael. And it's a pleasure to be here. This is a topic I recall a decade ago at law school in the early stages of the Sabin Center at Columbia University, studying climate change law. We had a single class on climate litigation and kind of covered the space of it. Since that time, I think they now have entire semesters donated to this topic. So we're going to try our best in an hour to give the audience a sense of how we've had this massive growth in this area of litigation addressing the climate conference. And I think we have just a wonderful panel with us today to help us navigate that. So let me introduce them, starting with Rick Butcher. Rick is a former U.S. representative for Virginia's 9th Congressional District. He served there from 1983 to 2011. During his term, he served on the Committee on Energy and Commerce. He was also the chairman of the Energy Subcommittee, which drafted the American Clean Energy and Security Act. Thank you, Rick. Next up, we have Jen Danis. Jen is a senior fellow at the Sabin Center that I mentioned for climate change law at Columbia Law School. She previously served as the senior staff attorney for the Eastern Environmental Law Center's Energy Infrastructure Program, and her work included developing and implementing novel legal theories to prevent the proliferation of gas pipeline infrastructure. I will pause just and take an alumni privilege here. The Sabin Center is an incredible resource. If any folks, I think there's over 100 of us who are taking an hour today to learn about climate litigation. If you want to follow this area further, they have a complete taxonomy of all litigation cases. They have a great blog. And if you don't have time for either of those, I would suggest subscribing to their newsletter. It's once a month and gives you an update on everything that's been going on in this space. I'm been a subscriber for nearly a decade now. So just a plug to the Sabin Center. And then last but certainly not least, we have Phil Goldberg joining us today. Phil is special counsel for the Manufacturers Accountability Project. He works to help educate public policy in the legal community on litigation against energy manufacturers and whether or not that's misguided regarding climate change, obviously a topic we'll get into today. He also has over 25 years experience working with liability-related public policy, public affairs, and public relations. So thank you and welcome to the panelists. Jenna, I may start with you. As I mentioned, the number of cases in this area has grown from what could be covered in a 2-hour law school class to a semester, and in fact, it's more than doubled over the last 3 years. Can you start by just giving us a little bit of a sense of how big climate change has gotten, specifically rather climate change litigation, and what do you believe is sort of driving more and more plaintiffs to take cases to court?
Sure. So I think, the fact that this group is here today is a reflection of the fact that it has gotten quite big quite quickly over the last few years. And there's really a number of motivations for that. It doesn't mean that any of us have stopped working on all of the other advocacy fronts that we're working on. But what's really happening is that cities and states are right now footing the bills for adaptation costs as we're all experiencing in real time the impacts from climate change. And there are significant questions about how the cities and states are proceeding. They are certainly at the policy and the legislative level addressing emissions and mitigation. Adaptation is going to be exceedingly expensive, as we all know. And the longer these local governments wait to try to secure funds to protect their citizens, the more costly it gets. And at the same time, on the flip side, they need to be making good investment decisions from a policy perspective about how to secure an equitable and just transition. So I think the proliferation really has evolved from the stasis and in some cases rollback that we've seen at the federal level, and certainly the very incremental victories that have been able to be achievable in either through executive order or through policy, through legislation. They're an important piece of the puzzle, but right. We are at the critical juncture where something has to start moving the needle, and the economics of this need to change.
Thanks. And turning to you, Phil, Jen mentioned incremental victories, certainly there, and referring to executive action and other state legislation, but isn't the track record here that there's been very few victories in the courts so far on litigation? Is that your impression? And if so, why do you think plaintiffs continue to bring these cases?
Well, that's a very good question, Graham. And first, I want to thank you. And I can't say Rick, I have to say Congressman Boucher, because I worked on the Hill when you were up there. And so you're always going to be Congressman Boucher to me. And Jen, thank you so much for this as well. I'm really looking forward to this conversation and think it's going to be a great dialogue. And hopefully folks come away at the end of this with a little more perspective or knowledge than they started this with. And so I'm really looking forward to this dialogue. To get to the heart of your question, we're in the second round of climate litigation right now. The first round was brought probably what you studied back in law school, starting around 2004 with AEP versus Connecticut. And that went up to the US Supreme Court, where the court said, energy policy can't really be decided in a case-by-case ad hoc basis. That there's a lot more that has to go into it, and the judiciary doesn't really have the tools to be able to handle that. And this is really national legislative in nature. And then there was a period between around 2012 to a little bit few years after that, where the people who were behind this litigation tried to retool and figure out, okay, how do we now bring lawsuits in light of AEP? And back then, they freely said this is about using the courts to regulate emissions and try to deal with climate change, and have the courts take over the policymaking function. And so there are these lawsuits that were brought starting around 2017 that are trying to look different from AEP versus Connecticut. So instead of federal public nuisance law, state public nuisance law. Instead of suing the energy users like the utility companies, they're suing the energy manufacturers. Instead of seeking injunctive relief, they're seeking damages or abatement, depending on how you look at it. And so they're trying to package the cases a little bit differently, but at the end, they're still trying to do the same thing. And there's a lot of forces that are behind it. I would try to break it down into three groups. You've got the advocacy groups that are trying to use the litigation for policy purposes, and their goal is really just to recruit and file as many of these cases as possible so they could try to get the political and policy benefit out of this they're looking for. You've got the lawyers who are bringing the cases, who are being funded by these groups, and so they're out there trying to do that work. And then you have the communities, as Jen said, that are saying, hey, we've got to figure out what we're going to do here. And if we can get money from somewhere outside of our community, hey, that's better than than otherwise. And so those forces are coming together to really to get as many of these cases out there as possible. That's their goal, because they understand ultimately what they're trying to do is to get a state court to ignore what the Supreme Court said, and they want to have as many bites of that apple as possible. So they could try to get a state judge who will say, hey, I want to solve a problem for my constituents. I'm going to not follow the Supreme Court ruling, and then try to drive that, those outcomes. And so I think that's why we're seeing this multiplication in recent years, along with the frustration that many people feel, including myself and including others on this webinar, about the lack of progress in Washington on climate change and on almost every other issue that we care about. So, at the end of the day, we can't sue our way out of climate change. We have to take this, we have to have policy measures, we have to have innovation, we have to do the things that get us to where we need to get to. Right. And so that's why we think the litigation isn't the appropriate way to go about it.
Sure.
Let me just comment, if I might.
The government
Yeah, I'm sorry, did I interrupt?
No. I was about to pass the contract that I think your perspective on the policy and the interplay of putting pressure on the policy through the courts is. Do you think that that's happening here, and is that being effective?
Well, I think Jennifer is right in saying that there's massive frustration. The federal government has not done what it needs to have done. It has been extremely slow to react. It's one step forward, one step back, and it's been like that now for well more than a decade. On the regulatory front, that's exactly what's happened. And in terms of legislation, the last thing that we saw was the passage in the House in 2009 of the Clean Energy Security Act, which would have put a price on greenhouse gas emissions by means of a market mechanism. It was an allowance trading plan, somewhat similar to what the European Union had implemented in response to its obligations under the Kyoto Protocol. And we tried very hard to pass that. I had a role in trying and shared the frustration of others in Congress that while we passed it in the House by a narrow margin, we got no receptivity in the Senate. It was never taken up in committee, certainly not on the floor, and so it came to rest. And Congress really has done almost nothing since in the sphere of trying to address in a meaningful way greenhouse gas emissions. Now it's time for that to change. So, why do we have a multiplicity of lawsuits in the states? I think it's born of frustration as much as anything. Looking around the framework As we see it, what I think localities see is huge damage occurring. Climate change is the greatest existential threat that the planet faces, and localities are bearing the brunt of the damage, exactly as Jennifer said. And so there being no other ready tool at their disposal other than talking to their member of Congress and getting a yes, yes, we'll try, which is all it's been so far, they're heading to the courts. I think that's a highly inefficient way of trying to address the problem. The courts simply don't have the tools to do this. They can't weigh critical factors like the need to have affordable energy for consumers. They can't effectively weigh the national security implications of power supply. These are all factors that Congress is well positioned to weigh once they get around to the issue. So I have hope for the future from a legislative perspective. We can talk more about that as the hour proceeds and the reasons why. But yeah, I get it. I mean, I know why the localities are frustrated. Their back is up against the wall and they're responding, and you can hardly blame them. But it's from the standpoint of national interest, not the right approach.
Sure. Maybe can I turn back to you, Jennifer, on that? You know, we're hearing that this is sort of born out of a messy frustration. I like that phrase, and trying to find different ways to overcome the Supreme Court's decision in AEP. But there, along the way, though, there have been some victories. Can you maybe give a little bit of a picture of where you see progress being made on the courts, and not just as an arena to sort of vent this messy frustration that Rick talked about of being able to not see progress in other forms?
Sure. I mean, I think the progress has proceeded along the same lines as it has, you know, in the histories of securing other kinds of rights, all of which have been secured in state courts, you know, and rarely has any right been secured without litigation. I think, you know, just as we've seen and everyone on this panel is well familiar with, it has taken a very similar push, whether it's asbestos litigation or cigarette litigation, to really hold people accountable for health risks. And, you know, I think states have been successful where, and localities have been successful where courts are being truthful about the origin of police power and who's really responsible at the end of the day for the health, welfare, and safety of the citizens. And I think that to the extent, you know, I mean, you can tell the story of this is people trying to get around AEP. We all know AEP was about something different. You can create a false dichotomy that it's litigation or congressional action. I think we're at the point where it's everything all in, because we need to address adaptation. We need Congress to move and address mitigation and emissions. We need for these companies that have been kind of hiding the ball for decades to internalize the costs that all the cities and states are paying right now today. So I think that, you know, that certainly the successes in the recent spate have been a very clear message from every federal circuit court that's considered the issue that state courts are in fact very adept and capable at adjudicating precisely this kind of cases. Nobody's trying to make an ideal policy through the courts, but states and state judges that are not subject to the same kinds of corporate pressures that we all know, you know, federal policy can succumb to, are really a good place for this individualized adjudication. Is a coastal city going to need the same kind of funding and bear the same kind of impact as a Midwestern agricultural city? No, there are going to be different kinds of damages here, and it's exactly the right forum for those kinds of lawsuits, and state court judges are adept at wading through the factual distinctions that are going to be at play here. And I think that's what the federal courts that have looked at this have really found. So I see that as a success, that federal courts acknowledge that state courts are traditionally the forum for these kinds of claims and also are particularly well suited to address them.
Phil, I want to let you respond to that, and maybe also as a counsel that often represents the other side of this with your manufacturers accountability project. Do you see manufacturers and other potential defendants, are they starting to assess the risk of litigation? Like, is there that kind of expectation, or is there any behavioral change that you're seeing from the proliferation of these lawsuits and the potential or possibly even likelihood that folks in the fossil fuel industry may find themselves on the defendant's side of these cases?
Also a very good question. I think manufacturers, generally speaking, are concerned about these lawsuits because what they try to do, sort of, if you take the look at the 50,000 foot level, is to identify a political or a social or an environmental issue that is concerning for sure, and then try to say, okay, let's see who we could try to get, who we could try to sue and try to get money from to try to solve this, and skipping over traditional legal principles like wrongdoing, causation, all the things that in traditional legal theories that have the theories that are being tried here are very novel uses of these theories. And so it almost is like that expression, throwing spaghetti on the wall and seeing if anything sticks is kind of how I see this litigation. It's just, well, let's try this, let's try this. It's almost like you're in a legal laboratory of trying to figure things out. But at the end of the day, this is not about who knew what when with regards to climate change. This is something that governments have been studying, industries have been studying, international bodies have been studying for decades, and there's been discussion among those groups and including the public about it. And I, as Congressman Boucher could probably give us more detail, the challenge is not the lack of knowledge to act. It was the disagreements of how to act and get things done in a policy realm to try to figure out what we're going to do about this. And so now that there's frustration, and again, understandably so, that not enough has been done, particularly in the last decade or so since Congressman Boucher left the House, that that's like, okay, let's just try this one other area. Let's keep seeing if we can try the liability angle to see if we can get something out of it. That's not useful, particularly when, as Jen indicated, the impact here would be, as she used the phrase, internalize the cost. Others have said, the goal is to hold consumers accountable, or this is about increasing the cost of energy, when there's real impacts on everyday people who are already, saying, I can't fill my car with gas because I can't afford $5, $6, $7 a gallon. If all of a sudden the energy companies had to internalize these costs of retrofitting infrastructures, the price of gas is going to go up double. And there's a great op-ed I saw by a former House of Representatives or Colorado House leader who said, if once you get to $100, $120, $130 to fill up your car, that's a day's wage for a lot of people, and people just really can't afford that. And so, I think that these are serious implications of these lawsuits. That the only place that we can balance all those factors is in Congress and legislative bodies, not the court.
So let me turn to Rick on that, because I'm curious, Rick. As a former congressman, when you are seeing all of this action at the state level that Jen and Phil have talked about, with all of this litigation and whether it's strategic or just sort of throwing spaghetti at the wall, but trying different avenues to sort of fill that what we all recognize is a policy void. Maybe it's complementary, maybe it's in lieu of. But do you think that is creating any pressure on Congress there? Is that another implication of some of this litigation, that it may help create more conditions for policy at the federal level? Or do you think that this is mostly just noise when you're in Congress?
there's so much going on in the space that I think it's background noise. It's absurd. I think members of Congress who are focused on these issues are certainly aware of these lawsuits. My sense is there's some expectation that when the proper case is brought before the Supreme Court, they're going to expand their ruling in EPA versus Connecticut, which basically held that federal nuisance laws are preempted by the regulatory authority of EPA. And that was true whether EPA had actually issued regulations or not, because at the time of that ruling in 2011, EPA had not actually issued regulations on greenhouse gases. But the court held, notwithstanding that fact, the mere existence of the regulatory authority preempted the federal common law nuisance claims that were the basis of that case. Now, the court decided not to extend that holding to state common law nuisance claims, and the cases we're talking about now, the Baltimore case and others, are based on state common law nuisance. What the court said is that the issue was not brought before them in a fully briefed and argued way, and therefore they didn't need to reach that holding in order to make their decision, so they were more narrow about it. But they clearly left the door open for further consideration once the case is brought to them and briefed and argued. And I think members of Congress who are focused on these questions probably anticipate that these cases are going to be dispatched by a Supreme Court ruling applying exactly the same logic that led the court to declare that the preemptive effect of these EPA regulatory authorities applied to federal common law nuisance and extend that to state common law nuisance also. That doesn't excuse Congress from acting, and I don't know whether the time is right now to talk about why congressional action is feasible. I happen to think it is, because the landscape has changed pretty substantially in terms of the factors that members of Congress look at since the House passed the Clean Energy Security Act in 2009. There are different factors at play, and we can discuss those when you think the time is right.
Yeah, I do want to come back to that question of whether in the future that policy, effectively the success or the existence, even success is maybe too high a bar, will eventually make the need for these cases to fall away. But I want to come back to you, Jen. We're sort of hearing a little bit of I won't say negativity, but the limitations of these state law claims, and perhaps from Rick, an expectation that they're a bit time barred and pretty soon may time out. Is that from the cases you guys are tracking at the Sabin Center? Is that your perspective, or do you think that maybe some of Phil's spaghetti noodles are actually going to stick here, and we may be able to make a meal out of this? I will apologize for that pun. It's Phil's fault.
Yeah, well,
my kids would say that was a great dad. Good.
I unsurprisingly, I think I disagree with the idea that federal common law and state common law stand as direct analogies for each other. They certainly have very, very different structural and historical grounding and serve very different purposes. They're also called out very differently in relevant statutes. But beyond the crystal ball, which I would not pretend to have with this court, especially as we all await what June brings us, I think that I just want to respond to the idea that these have no chance of success. If 100% chance of success was our bellwether for whether or not to file a lawsuit, I'm not sure that advocates would ever file a lawsuit. I'm not sure civil rights advocates would ever file a lawsuit. Sometimes you do it because you're doing what's right, and whether you're right on the law, you can still lose. I once had a case about endangered species, and I was told point blank that I was going to lose because they're snakes and nobody likes snakes. So we all on this call know that what the law says and what the facts say, and doesn't necessarily have a bearing on the outcome. I do think that these cases are serious, are well thought out, are strategic. They are not the spaghetti on the wall. They are the, the dish at the gourmet restaurant that really stands alongside of all the other work that advocates are doing. I'm a litigator, but I also work in a number of other arenas, and it's not an either. It's not an either or. I think it's really important, though, to just circle back to something that Phil said about the narrative of, this is going to hurt people at the gas pumps. I mean, people are hurting. There's no doubt that people are hurting. But when you have oil and gas companies recording record profits to their shareholders, I'm not quite sure there isn't more there than a direct nexus to our climate lawsuit for damages is going to force prices to go up at the pumps. That certainly is a corporate decision of how they would want to handle an outcome or a victory. But it's hard to suggest that there's a direct correlation other than by, corporate decision making of where to allocate costs and profits.
Sure. Phil, I want to give you a chance to respond to that, and also maybe just if you can touch on, you raised earlier that these are complicated questions about, some of the fundamentals of tort law, causation. For one example, obviously we have a climate change, as everyone is well aware, is obviously a global issue with a lot of many different contributors, some more than others. But certainly, is it fully true that courts can't handle sophisticated, complex litigation? I mean, particularly in the area of environmental litigation, and Jen mentioned earlier, asbestos, for example. The courts have dealt with, especially on the state law side, relatively complicated issues in the past. What makes climate so different here that you feel that this really isn't the arena, and perhaps based on most of the outcomes to date, maybe judges are agreeing with you?
So I just want to get to the premise of your question for a second. Absolutely, courts can handle complex matters. It's a question of complex liability matters versus complex policymaking. When we're dealing with, there are the traditional common laws and state laws that are applied in the liability context look at the core of any of those theories, whether it's negligence, nuisance, Consumer Protection Acts. It all comes down to wrongful causation. Did you wrongfully cause the harm in which you're being asked to pay? And there are standards that are in the law as to what you need to be held accountable for. And if you don't meet those standards, if your product's defective, if you breach duties you have to somebody, then you can be subject to liability. What we need here are policy-making decisions about how to deal with greenhouse gas emissions, how we're going to address mitigation needs of communities, and they're trying to just skip right over that wrongful causation aspect of this, because at the end of the day, these liability theories don't work in this context. And public nuisance is about protecting public roadways and rivers, not about things like that are outside of sort of local communities of like climate change, where you're dealing with sources from around the world for 150 years, and how are we going to manage that? When one of the lawyers in the cases in one of the recent appeals was asked, you say this isn't about emissions, because if it gets to emissions, then that becomes a federal issue. And at the end of the day, he said this is about their belief that these companies exacerbated emissions. So it's, at the end of the day, this is about the impact that emissions are having on local community, and they want to get at those emissions. And that's what the Second Circuit said last year when it ruled to dismiss New York City's climate case. Is it said that these are, I have the the exact phrase. They said, "We are told this is merely a local spat about the city's eroding shoreline, which will have no appreciable effect on national energy or environmental policy. We disagree. Artful pleading cannot transform the city's complaint into anything other than a suit over global greenhouse gas emissions. And then it dismissed the case. A lot of these other cases that are out there, they're still dealing with procedural issues that would make most civil procedure professors numb, let alone us on this call. This is the one court that got to the substance of what is going on here, and they were issued a very clear ruling that said these aren't justiciable issues. These aren't liability issues. They're policy issues meant for the policy bodies, which is Congress and the agencies.
Maybe I'll go back to you on that, Jen. Obviously, there's the New York case is a great example of sort of what Rick and Phil have been talking about as climate change as ultimately something that needs to be dealt with at the policy level. But you've been saying before that states are looking at they're experiencing real damages and trying to attribute damages perhaps in the absence of federal policy. Is there other areas that you feel like the states have been successful here and as ways to avoid the litigation falling into a trap of federal policy?
Yeah, my impression of the Second Circuit case is quite different from Phil's. That was just putting my litigation cap on here, a very specific procedural posture was brought in federal court, dealt with ordinary preemption, not complete. I mean, there's a million differences, and every other circuit court cited the Second Circuit and specifically talked about why the Second Circuit case did not stand for that substantive proposition that this is about federal policy. So I think, it's a little bit overstating what the Second Circuit was actually adjudicating. But, really beyond that, I don't believe that anybody thinks that these state court cases are about making federal policy. Again, federal policy needs to happen. Federal legislation needs to happen. None of the cases are asking for the companies to stop emitting. None of the cases are asking for, that these are, and people just kind of like to forget about it because now we all know that these emissions cause climate change. But this is about companies that were sitting on data and information and marketing their products while internally their papers said something different and they were hiding the ball on it. So it's not about federal policy, it's about corporate deception at the core. All of us who are in this space are also very interested in federal policy and getting policy right and getting the economics right and the idea of a carbon tax and how that would work. And certainly, the other side of this coin about a just transition. I mean, if I were an oil or gas company, I'd be really understandably upset that I've been putting this out there and now somebody's asking me to have to direct some of my profits towards addressing the harm that I've caused. Again, just because you were allowed to cause the harm doesn't mean you shouldn't have to pay for it. So I see this, these state court cases as directed, narrow, and a complement to what advocates are working on in these other arenas. I'm not sure why you can't have both. So I'm really curious as to why this is, the paradigm here is should it be this or should it be this?
Right. Well, and let me turn back to Rick and Phil on that, because what you're talking about to me, and I'm certainly no expert in the area, but it sounds a little bit like some of the tobacco litigation, right? Tobacco manufacturers were allowed to sell cigarettes. That wasn't against the law. And yet we all know that over time, and I believe it was state courts, I think Florida was one of the first big ones, were held to massive liabilities. To go back to your wrongful causation theory, Phil, whatever Marlboro, I guess, I'm not a smoker, so did was legal, and yet they and many other tobacco companies faced massive litigation. Obviously, we're seeing the same thing on the opioids, right? The Sackler family didn't break the law, but yet they're being found to have caused a lot of harm. So is there not some parallels here with what's happening in climate litigation to some of these other strategic litigations often that does happen at the state level, and thinking about tobacco or opioids, or what is so different here than what's come before? Sorry,
Phil,
I put that
do
out
you want to talk
there.
Congressman. Yeah, so this is not the current litigation in the climate cases are not about, I think I said before, who knew what or when, and this is knowledge that was had for decades by a lot of different people and a lot of different governments who were responsible for creating energy policy, including today in the administration today, that is in response to the horrific events in the Ukraine, is asking for more production of energy, of oil and gas, and these fuels. So it's not that the narrative that somehow what was said or done it put us in the situation we are in today just doesn't hold up. And there have been different attempts to try to do this. And I will say, back in 2012, I think it was, there was a meeting in California, and then they put a report on the internet about how they're going to try to turn climate into, the next, to kind of mimic what they did in other litigations. And someone at the meeting, according to the report, said, that the importance of creating some sort of scandal and try to vilify the companies and try to say that they did certain things that were wrong. And some of that's been tested already. And it was one case that the Attorney General of New York brought, where the state court there said that the claims were hyperbolic, they're breathtaking. Another court called it lawfare, using litigation as sort of a warfare tool. So the allegations, when they've even been looked at, haven't really held up. It's more part of this public narrative that they're trying is going back to what we said at the beginning of at the top of the hour, to try to use the litigation as a tool to what they've said, and again in their materials is about trying to make these companies harm them politically in Congress, so that they try to create this friction, and so that's what this is. That's what they've said. This whole sort of campaign of deception, as they've termed it, is really about. And so it has, and again, it hasn't borne any fruit when it's been looked at by courts.
Rick, I want to let you to respond to that in particular. Whether you see any of this, taking Phil's point about kind of vilification of fossil fuel industry, the fossil fuel industry through some of this litigation. Do you think that that's being perceived that way on Congress? I sort of asked the question before whether or not this is creating the support for legislation. You sort of said it's in the background, but it sounds like, according to Phil, it's even a little bit more say public relations-y than that, if the purpose here is to sort of say these are the bad guys and we need to do something.
Well, vilification is never a successful legislative strategy. I've learned that over my time in Congress, that no matter how angry you get, no matter how justified you may feel in pointing the finger at someone else, it's not a means to the end. You may enjoy the fight, but you're not going to get the outcome that you want. So putting all of that aside, I mean, I think we ought to acknowledge some of the fundamental changes that are occurring, because they bear directly on this discussion. In 2009, when we passed the mechanism for controlling greenhouse gases, the emissions trading system, the only companies that as a group supported our bill were the electric utilities. And the coal-fired electric utilities, American Electric Power, Dominion, Duke, were the leaders. They were the ones who were the most supportive of our bill, and their CEOs actually traveled the country giving talks about why it was time to control greenhouse gas emissions through this trading mechanism. Now, it was carefully balanced. It was designed to take into account the things Congress has to consider: the need for affordable electricity, the need for national security, because power supply is essential to that as well. And so I think the utilities were convinced that it was sufficiently balanced, allowing them to engage in credit offsets to the extent that they actually could continue their business at a higher cost, yes, but they could continue effectively producing electricity. And so they saw this as a reasonable approach and supported the bill. The oil companies were nowhere to be seen. I don't think they even felt like they had to raise much of a voice in opposition, but they certainly were not supportive. We didn't get much help from the natural gas industry. The coal industry was definitely opposed, and probably if you ask a lot of the coal executives today, they would tell you that they're fine with nothing having happened. The fact remains, however, that changes have occurred, and I think we should acknowledge those. Today, under the umbrella of the Climate Leadership Coalition, a large number of America's biggest companies have endorsed the idea of putting a price on carbon. It seems that they are talking more about a carbon tax than they are some kind of emissions trading mechanism with a cap. I mean, just to divert for a second, that did not poll very well when we tried it in 2009. The public didn't respond favorably at all to the notion of cap and trade. Not that people really understood it, but it sounded pretty terrible. It sounded like something was going to be capped for them, and they simply didn't like it. And it was a complex mechanism. There's no doubt about that. The typical person simply didn't understand what it was Congress was proposing to do. They were told in TV ads by the opponents that it was going to raise energy prices, and that's pretty much what the public needed to know. So it was not popular.
Right.
And probably would not be the preferred approach now, again, because the complexity hasn't gotten any easier. And if you put that measure forward today, I doubt it would achieve success either. So the carbon tax would seem to make more sense. And the oil companies, who were strongly, well, agnostic is a generous term, but they certainly were not supportive of what we were trying to do in 2009, have now said that they're, for the most part, in support of a carbon tax. The American Petroleum Institute has taken that position. Some of the leading majors, Exxon, Chevron, to name a couple, have taken that position. And they would carry real political clout going to Congress, talking primarily to Republican members and saying the time has come to have an understandable, straightforward pricing mechanism. Once we know the price, we can work our business model around it. But having the clarity of a price is important to us, rather than the uncertainty of a stop and start regulatory environment that they have a great deal of difficulty pricing. So that I think they see that the time has come. And that is fundamental. They've changed their conduct in other ways. There was a proxy fight in the case of Exxon that was successful, and new board members were elected to the board who very much wanted to address climate change problems. I think some of the other oil companies observing that event decided to put climate-friendly voices on their boards also. So internally, change is beginning to happen. And that's culminating now in a public position by the largest oil companies saying the time has come to have a carbon tax. I think that would be heard. So Congress needs to do this work, and to all the encouragement they can get, they need the voices of local governments, instead of going to the judges, ought to be going to their members of Congress and saying, look at the harm we have here. Come to your district, come to your state. Let us show you the damage that climate change is causing today, and it's only going to get worse if you don't do something.
Apologies to jump in here. This is Kevin Marin with Our Energy Policy. We do want to leave a little bit of time for questions from the audience here at the end. Before we jump in there, any last short final thoughts from our panel? All right, well, we'll leave about 10 minutes for questions then. Starting off here, since 2015, several key multilateral agreements have been passed, some non-binding, while others are part of international treaties. Do these agreements help climate litigation in the United States and elsewhere? If we could broaden that, I guess the question would really be, do you see any implications for kind of more large-scale treaties and agreements, implications for climate litigation in the US?
Jen, do you want to take that? Do you see some of what's happening? For example, the Paris Climate Conference and even perhaps some of the new net zero alliances. Do you think that some of those voluntary commitments do become fodder and ripe for part of the role of courts here to sort of police whether or not those commitments are being made, or is that more sort of, as they say, greenwashing and marketing?
I'm not sure that I see that as a really big catalyst for the energy transition that this country has to undergo. And I would definitely think, in terms of national security and other things that we have to consider, certainly what we've seen from overseas is that the most robust way to have that is to reduce our reliance on particular fossil fuel companies and projects.
Thank you for that. We've actually had a couple questions on the potential, apologies, was there another thought there?
Yeah, I was gonna jump in and say that, I think that, the treaty route is again part of the policy mechanism that, I think Congressman Boucher was talking about is kind of the right way to go about doing this, because this is global in nature. This is something that we, if we are reducing our use of fossil fuels here, and there was an article in the New York Times last October that kind of went through this and said, already as American and European fossil fuel companies are reducing their output, that is being taken over by Saudi Arabian, Russian, and other other oil producers. And they said in the article, we're happy to fill that void, and they're going to. And as I don't remember the exact numbers, but use of foreign energy is going to go up. They said to about 75%, or maybe it was around 45% now over the next 10, 20 years. And so that's not going to shift the dialogue and the solutions if all we're doing is shifting energy production to places where are less friendly to U.S. interests, that don't have the commitment to the energy and to the environment and climate that the European and the United States companies have, that Congressman Boucher was just talking about. And so, but interesting though is that the lawsuits only are suing the U.S. and the European companies. There was an article I read by a national security expert that raised some real concerns about that these lawsuits aren't suing Saudi Arabian oil and gas, is the largest oil and gas producer in the world. They're not Russian, not others, just US and Europeans saying, you should have to shoulder these costs, even though you're just part of one industry that's part of modern society that is leading to the climate change. And I think at the end of the day, we all recognize we need to change the way that we're using and sourcing energy to make it more sustainable for the climate. That's not, that's indisputable. The question is how we're going to get there, and these lawsuits don't get us there, and they can actually make things worse.
Thank you for that. We have a question here. If the Supreme Court suddenly ruled that the EPA does not have jurisdiction under the Clean Air Act to regulate greenhouse gas emissions, would that impact suits for other acts, such as the Clean Water Act, or would that impact any ongoing legislation?
Let me comment on that. I can't imagine that happening. I think it's a hypothetical beyond the value of discussion. In Massachusetts, in the Massachusetts case in 2007, the Supreme Court had the watermark holding that the Clean Air Act confers regulatory jurisdiction upon EPA over greenhouse gas emissions. And I can't imagine a direct reversal of that decision, just a handful of years later. So I don't know. End of comment.
No, I think that's helpful, but it does jump into another couple of questions we received about, for lack of a better term, the potential for anti-climate litigation. Are there concerns that we may see an increase in challenges to state-level climate policies as a result of the publicity around climate litigation? Or, is that something not to be concerned about?
Jen, is that something that you guys track? Like, I know that a lot of the cases that the Savin Center follows, it tends to be climate on the side of the plaintiffs. But have you guys been tracking cases where people are using findings such as the one Kevin mentioned in this question against as a barrier to policy action?
I mean, there's nothing that particularly leaps to mind about the connection or relationship between those two pieces. I mean, I would imagine that anything that would be brought against state or local climate action would be just you've exceeded your authority, which again, at the state level, the police power is quite a strong and robust authority, or a takings type claim, and that assumes that people have the right to pollute. So I'm not sure what structurally those lawsuits would be predicated on, but again, I don't see that as any kind of a backlash, and I also frankly don't see the downside that folks keep referring to about cities and states trying to protect their citizens through these climate nuisance actions and product liability actions.
Let me just add something. There is a downside, and that is that it's a diversion and a distraction from what Congress ought to be doing. And let's not forget that this is a global problem. The emissions don't only come from the United States. China alone rivals the US in terms of the volume of greenhouse gas emissions every year. The developing world, including China, combined would certainly greatly exceed the United States in terms of the volume of emissions. So if we're going to do something meaningful about attacking the problem, it's going to have to be a global solution. Now, the United States has been trying to get to a global solution. We had a large role in negotiating and helping to get put forward the Kyoto Protocol. We did the same with the Paris Agreement. The time has come for the US to reassert that role, but we're poorly positioned to do it when we haven't really meaningfully controlled greenhouse gases ourselves. How do we say to the developing world, where people look to the US as fully developed and say, you've had the advantage of full development all these years, emitting lots of greenhouse gases, and you're still not controlled, and now you're asking us to control? We don't have the moral authority at the moment to make that request. But if we imposed our own regulatory regime, and it was a serious regime, a carbon tax that was meaningful, that escalated every year somewhat above the level of inflation, if we did that, we would then have the authority needed to go to the developing world to say, it's time for you to get on board also. And I think we'd get a much better reception for that than we're currently getting. So litigation doesn't get us there. That's just Americans squabbling among themselves. People in India are going to look at that and they're not going to be moved one way or the other by it. But if we had our own regulatory program, we'd be strongly positioned to make an argument to them.
Sorry, go ahead, Jen.
I was just going to respond to that and say, actually, I believe the opposite, that if state courts started holding companies accountable, that would certainly increase the US and the perception overseas that the US is not interested in corporate accountability. So I actually think it would have the opposite impact.
Which is a great point to end on, although I hate to say that we have to end because it's been such a fascinating discussion. But that, kind of dialogue at the end, which really lays out the importance of really talking these issues through in a thorough, substantive, and civil way is what we're about. And we will make this available on our site. We're going to promote this very, very important discussion throughout our community. I want to thank the audience who was able to join us today. Again, recommend to you the use of the Our Energy Library. Those resources at our site include a number of materials that are very specific to the discussion today. Obviously, I want to thank Graham, Rick, Jen, Phil for a terrific discussion. Thank you for taking the time and for the stimulating insights that you provided. And thanks, of course, both to all our partners, but particularly to our co-host today, Eberson, and to Michael Dorsey for his thoughtful opening remarks and laying things out. So once again, to everyone, have a good rest of the week, and thank you. And we look forward to further discussions on this. Graham, did you have a last comment?
No, I thought it was a wonderful discussion, and appreciate the different perspectives. And I imagine this is a topic we'll likely return to again. I don't think anybody thinks maybe we'll get Rick's policy at the federal level. Maybe we'll get Phil's decision by the Supreme Court to put a lid on this. But barring either of those, I think this is an area that's going to continue to grow. And one that I imagine folks involved in our energy policy will want to stay on top of. So hope to continue this conversation.
Thank you for that, and 100% agree. It's of tremendous importance, and we do intend to stay on top of it. So thanks again to all of you and to everyone else, and have a great rest of your day. Thank you.
Thank you.